A lot of you saw the headline-style post saying, "Just passed today, new U.S. immigration law shocks green card holders. Must watch now." And I want to start with the most important point. Right now, based on the information in that claim alone, we do not have enough verified specifics to say an official new federal immigration law has taken effect, or that your green card status changed today. But we can still do something very useful in this video. By the end, you will know 3 things. 1. What you can verify in minutes to separate real policy changes from viral noise. 2. Which green card holder situations are actually more likely to run into problems in 2026 if rules or enforcement shift. And 3. A simple do this and avoid this checklist for travel, paperwork, and compliance that protects you even if nothing changes. Here is the part most people miss. In U.S. immigration, big-sounding headlines do not automatically equal an immediate rule change. Even when something passes, the details matter. What exactly passed? Who signed it? Whether it is a law versus a proposed bill. Whether it is a regulation versus an enforcement memo. What the effective date is. And whether agencies like USCIS or CBP have issued guidance. If you do not have those pieces, you do not have a reliable update yet. Now, why is this trending? Typically, a post like this can come from a few different sources. A bill passing one chamber but not becoming law, a state-level change being mistaken for federal immigration law, a court decision being described as a new law, an agency policy update being overstated, or sometimes just clickbait. And I am not saying nothing happened. I am saying we should treat the word passed today as unverified until we can point to a specific, checkable source. This is where people get denied or delayed. They panic, make sudden decisions, cancel trips, abandon applications, or file random forms that create confusion later. So we are going to slow down, stay calm, and focus on what is always true for green card holders, and what could realistically change in a way that matters in 2026 and beyond. First, let us define what counts as a real change for a lawful permanent resident. Your green card status is created by statute and managed through a mix of laws, regulations, and agency policy. In real life, changes that affect green card holders usually show up in one of 4 ways. 1. A new law that changes eligibility, obligations, or enforcement tools. 2. New regulations that adjust procedures or standards. 3. Agency policy guidance that changes how officers apply existing rules. 4. Enforcement posture changes that increase scrutiny at places like airports, interviews, or during certain types of applications. And almost always, there is an implementation trail you can track. An official publication, an effective date, updated forms or instructions, and public FAQs. If you cannot find those, you should assume the viral headline is incomplete. Now let us talk about who could be affected if there really is a change coming that targets compliance, travel, pending applications, or long-term permanent resident status, like the brief suggests. I am going to break this into high-risk, medium-risk, and low-risk buckets. High-risk bucket number 1. Green card holders who spend long periods outside the United States, especially trips that look like you moved abroad. The reason is not new. It is because permanent residence is about living in the U.S. as your primary home. Long trips can trigger questions at the border about abandonment of residence. If in 2026 there is any new compliance requirement or just tougher questioning, this group feels it first. High-risk bucket number 2. People with criminal issues, including old arrests, convictions, or even pending cases. Again, I am not making a claim about a new law today. I am saying any shift in enforcement or rules tends to hit this group early, because admissibility and removability questions can come up during travel, renewals, or naturalization. High-risk bucket number 3. People with paperwork inconsistencies, like a green card that is expired, an address that was never updated, tax filings that do not match residency claims, or long gaps in employment history that are not well documented. Small detail, big consequence. When officers review a record, inconsistencies create scrutiny even if you are eligible. High-risk bucket number 4. People with pending immigration applications where the story matters. like naturalization applications, removal of conditions for conditional residence, or family-based filings where there are prior immigration issues. A change in policy guidance can change the type of evidence officers expect, even without changing the law. Medium risk bucket. Frequent travelers, people who live near the border and cross often, students or workers who recently became permanent residents and still have ties abroad, and seniors who travel for long caregiving trips. Low risk bucket. Green card holders who live in the U.S. consistently, file taxes as residents, keep documents current, and have no serious legal issues. That group is usually not affected by viral breaking news posts because most real changes come with transition rules and time to comply. Now let us do a quick myth versus reality, because this is where panic spreads. Myth: a new immigration law can instantly cancel your green card overnight. Reality: for the vast majority of lawful permanent residents, status does not disappear overnight from a headline. Even when laws change, there is usually an effective date, and there are due process steps for anything that would take away status. That does not mean there is zero risk. It means you should not make irreversible decisions based on an unverified post. Here is another myth versus reality. Myth: if your physical green card expires, you lose your status. Reality: the card is proof of status, not the status itself. An expired card can still cause practical problems, like travel, employment verification, or getting a driver license, but it does not automatically mean you are no longer a permanent resident. The practical impact matters though, especially at airports, so we will cover what to do. Next, travel and re-entry, because the brief specifically mentions travel considerations. What actually triggers problems at CBP is rarely just a single trip. It is the pattern and the facts. Officers look at things like, how long were you outside? What was the reason? Do you have a home in the US? Do you have a job or ongoing ties? Where do you file taxes? And what is your intent? If your life looks like it moved abroad, that is where questioning gets tougher. Here is the part most people miss. Even if you are admissible, a stressful CBP interaction can cause delays, secondary inspection, or paperwork you were not expecting. So the goal is to reduce friction. That means traveling with proof of ties when your trip is long or complicated. Examples include evidence of a U.S. residence, lease or mortgage, proof of employment or school, recent pay stubs, proof of family ties, and proof you filed U.S. taxes as a resident. Not everyone needs all of that, but if you are in a higher risk travel category, have it ready. Also, plan your timing. If you have a pending USCIS appointment, interview, biometrics, or an expected notice, do not schedule long trips that can cause you to miss mail or deadlines. Now, pending applications. People ask, could a new law affect my I-90 renewal, my N-400 citizenship application, my pending family petition, or an interview? The realistic answer is that laws and policies can change standards, evidence expectations, or processing priorities. But you usually see this through updated instructions, updated officer guidance, or public announcements about how USCIS will handle cases filed before and after certain dates. Without those details, you should continue your case normally and avoid doing anything that looks inconsistent. A small detail changes everything. If you have a pending naturalization and you take long trips, you can create continuous residence or physical presence issues. That is not new, but it becomes more important when people are nervous and start traveling unexpectedly. Now an example scenario, and this is a composite example, not a real person. Example scenario 1. Maria is a green card holder who needs to travel abroad for 5 months to care for a parent. She sees a viral post saying a new law passed today and green card holders will be shocked. She panics and considers canceling the trip and quitting her job. The safer approach is more boring but more effective. She checks for an official source. She documents her U.S. ties. She keeps her U.S. home. She keeps her job if possible or documents a leave arrangement. She files taxes correctly, and she plans how she will receive USCIS mail. If she has any past immigration complications, she consults a qualified attorney before traveling. The point is, you can reduce risk without panic. Now let us get practical. If you are a green card holder watching this because you are worried about new compliance requirements, travel and re-entry, pending applications, or long-term status, here is a do this and avoid this checklist you can start today. Do this. Verify before you react. Look for an official public source like a USCIS alert, DHS announcement, State Department notice, Federal Register publication, or a credible major outlet that cites the actual text and status of the change. If the post does not name what passed, treat it as unconfirmed. Do this. Keep your documents current. If your green card is expiring soon, plan renewal early enough to avoid travel and work headaches. If you moved, make sure your address is updated with USCIS if required for you. Do this. Build a simple travel folder if you take longer trips. Keep digital and paper copies of your green card, passport, and proof of U.S. ties. Do this. Track your time outside the U.S. Maintain a log of trips because it helps with naturalization eligibility and any questions about residence. Do this. Be consistent across systems. Your tax filings, your addresses, your job history, and your USCIS filings should not tell different stories. Avoid this. Do not rely on screenshots, forwarded messages, or creators who claim they have secret information. If it is real, you can find the source. Avoid this. Do not sign anything at the airport or border that you do not understand. If you are pressured, ask questions and stay respectful. Avoid this. Do not abandon a pending case out of fear. Missing a deadline or interview can create more problems than the rumor you are reacting to. Avoid this. Do not take extreme steps like giving up your home, switching your tax filing position, or moving your entire life abroad if you want to keep permanent residence, without understanding the consequences. Here is another myth versus reality that matters for 2026 talk. Myth. Anytime you travel, you are at risk of losing your green card. Reality. Most travel is routine. The higher risk comes from long absences, repeated long absences, or facts that make it look like you live elsewhere. So the goal is not to stop living your life. It is to avoid patterns that raise questions. Now, why might this be happening if there really is some new law or major change under discussion? Policy changes typically come from a few drivers: increased demand and backlogs, political pressure to show enforcement, national security or fraud concerns, and sometimes attempts to standardize how officers handle cases. Another driver is the mismatch between what people assume the rules are and what the law already says. Sometimes an update is not a new restriction, but a reminder and tougher enforcement of existing standards. That is why you will hear phrases like compliance requirements, even when the underlying rule has been on the books for years. Real-world consequences if scrutiny increases are usually very specific. Travel. More secondary inspections, more questions about where you live, and more referrals to deferred inspection in rare cases. Work. More employer verification friction if your card is expired or you do not have updated proof. Families. Delays when a petitioner or beneficiary travels and misses notices. Pending applications. More requests for evidence if your file has inconsistencies. And for long-term permanent residents, naturalization can become the moment where old issues resurface because the process involves a deep review of your history. Two groups are at highest risk here: people who have complicated travel patterns and people who assume old issues do not matter anymore. Now, what should you watch next for 2026? Instead of watching random posts, watch for these concrete signals. Signal 1. An official effective date. If there is no effective date, there is no timeline you can plan around. Signal 2. Updated USCIS pages, forms, or instructions. Signal 3. CBP public guidance on inspections or documents. Signal 4. State Department updates that affect consular processing, if your family is applying abroad. Signal 5. Court challenges or injunctions if a change is controversial. Signal 6. Processing time shifts and spikes in requests for evidence, which can indicate an internal policy shift even before it is widely discussed. Here is example scenario 2, also composite. Example scenario 2. David is a green card holder who recently changed jobs, moved to a new state, and has an N400 planned for later. He sees the viral claim and worries that a new law will create new compliance rules. The practical play is, he makes sure his address is updated everywhere it needs to be. He keeps records of his moves. He stays consistent with taxes and employment history, and he avoids long international trips close to any expected USCIS steps. If he has questions, he schedules a consultation with a qualified attorney, not because he is in trouble, but because planning prevents problems. Now, let us bring this home. We cannot responsibly tell you that a specific new immigration law passed today and will shock green card holders, because the input does not include the name of the law, the text, the effective date, or an official source. But we can still protect you with the right approach. Here is your 5-point recap. 1. Do not treat viral headlines as official policy. Verify the source, the status, and the effective date. 2. The most common risk areas for green card holders are long trips abroad, inconsistent records, and unresolved legal issues, not random breaking news posts. 3. Travel and re-entry issues are about patterns and ties to the U.S. Prepare a simple travel folder if your situation is complex. 4. Keep your documents current and your story consistent across taxes, addresses, and applications, especially if you have pending cases or plan to naturalize. 5. Watch for real signals like updated USCIS guidance, Federal Register notices, CBP updates, and clear transition rules before changing your plans. If you want, tell me in the comments what category you are in: traveling soon, renewing a green card, applying for citizenship, or waiting on a pending case. And if you found this helpful, subscribe and turn on notifications, because as soon as there is a verifiable, sourced update with actual text and an effective date, I will break down exactly what it means and what to do next in plain English without panic.